Welcome to our study of future interests in property law, a critical topic for the bar examination. A future interest is simply a property right to possess or enjoy property at some point in the future. These interests must be clearly distinguished from present possessory estates, which grant immediate rights to possession. We classify all future interests based on who holds them, either the original grantor or a transferee. If the interest reverts back to the original grantor upon the natural termination of the preceding estate, we call it a reversion. If the interest is held by someone other than the grantor, a transferee, it falls into one of two major categories: remainders or executory interests. Remainders follow naturally after a preceding estate ends, while executory interests either cut short a prior estate or create a gap in time. This chapter introduces this fundamental structure, setting the stage for a detailed look at these three core categories. We now turn our attention to the first category of future interests, those held by the original grantor. This interest is known as the reversion. A reversion arises automatically whenever the grantor conveys any estate that is less than a fee simple absolute. This includes estates such as a life estate, or even a fee simple subject to a condition subsequent. If the estate granted to the grantee is destined to end, the property right naturally flows back to the person who originally granted it, the grantor. Crucially, the reversion is always considered a vested interest. This means there is no condition precedent that must be satisfied before the grantor's right to possess the property becomes certain. The only requirement is the natural termination of the preceding estate. Because the grantor retains this inherent right to reclaim the property upon termination, the reversion is a powerful and certain future interest. Having established the reversion, which is the grantor's interest following a naturally ending estate, we now shift our focus entirely to future interests held by transferees, the people who received property from the original grantee. These transferee interests fall into two primary categories: remainders and executory interests. The critical distinction between these two lies in how they relate temporally to the preceding possessory estate. A remainder follows the preceding estate naturally. This means there is absolutely no gap in time. As soon as the prior estate ends, the remainder holder takes possession immediately. Think of it as a seamless continuation of possession. In stark contrast, an executory interest operates disruptively. It either cuts short the prior estate before it naturally expires, or it follows the prior estate but leaves a gap in possession before the executory interest vests. To visualize this fundamental difference in continuity, we must compare them directly using a clear diagram. Now that we have clearly separated remainders from executory interests based on the continuity of possession, we must begin the detailed classification of remainders themselves. Remainders are categorized based on whether the taker is ascertained and whether any conditions must be met before they take possession. The simplest and most certain type is the indefeasibly vested remainder. This remainder is indefeasible because the taker is already ascertained. We know exactly who it is, and there are absolutely no conditions, either precedent or subsequent, attached to the grant. Because there are no conditions and the taker is known, this remainder is guaranteed to become possessory when the preceding estate naturally ends. Consider the classic conveyance. To A for life, then to B. In this scenario, B holds an indefeasibly vested remainder. B is ascertained, and nothing can stop B from taking possession after A's life estate concludes. This represents the highest degree of certainty among all remainder interests. We just covered the indefeasibly vested remainder, the most certain type. Now we move to the next category of vested remainders, the vested remainder subject to open. This situation arises when the remainder is granted to a group, or a class, of people, such as A's children, or A's grandchildren. For this remainder to be vested, at least one member of that class must already exist and be qualified to take possession. However, the class remains open, because future events, typically births, could add more members to that class before the preceding estate terminates. Consider the conveyance. 2A for life, then 2A's children. If A already has one child, say B, B holds a vested remainder subject to open. B is ascertained, but if A has another child, C, later, C will share the interest with B. The key takeaway is that while the interest is vested because B exists, it is subject to reduction in size as the class expands. This uncertainty regarding the final share size is what distinguishes it from the indefeasible remainder. Having examined the vested remainder subject to open, we now turn to the final category of vested interests, the vested remainder subject to complete defeasance. This interest is vested because the remainderman is ascertained, and there is no condition precedent that must be met before vesting occurs. However, unlike the indefeasible remainder, this interest carries a built-in vulnerability. It is subject to a condition subsequent. If this condition occurs before the remainderman takes possession, the vested remainder is completely cut off, or divested. Think of it as a vested interest that is still vulnerable to being taken away. For instance, consider the conveyance. 2A for life, then to B. But if B ever becomes a lawyer, then to C, B's interest vests immediately upon the conveyance because B is ascertained and there is no condition precedent. But if B becomes a lawyer before A dies, C takes the property instead. The key distinction here is that the divestment happens after vesting, triggered by a specific subsequent event, unlike contingent remainders where vesting itself is conditional. We have now fully explored the three types of vested remainders. If a remainder does not fit into any of those categories, indefeasibly vested, subject to open, or subject to complete defeasance, it must be a contingent remainder. A remainder is contingent if it fails the test for vesting. This happens in one of two distinct ways. First, the remainder is contingent if the taker is currently unascertained or unborn. For example, if the grant is 2A for life, then 2A's first child to reach the age of 25. Until A has a child who hits 25, the taker is unknown. Second, even if the taker is known, the remainder is contingent if it is subject to a condition precedent. This is a condition that must occur before the remainder can vest. Remember, for vested remainders, we looked for conditions subsequent, which divest later. Here, the condition must be satisfied first. If either of these uncertainty factors exists, we label the interest a contingent remainder, signifying that vesting is uncertain. Having fully analyzed all types of remainders, we now shift our focus entirely to the second major category of future interests held by transferees, executory interests. Unlike remainders, executory interests do not follow naturally, they either cut short a prior estate or follow a gap in possession. We begin with the shifting executory interest. This interest is defined by its power to automatically divest, or cut short, the estate previously granted to another transferee the moment a specified event occurs. Think of it as taking the property away from the first grantee immediately upon breach of a condition subsequent. Consider this classic grant, 2A and his heirs, but if liquor is ever sold on the premises, then to B and his heirs. Or initially holds a fee simple. However, if liquor is sold, A's estate is immediately cut short, and the property shifts directly to B. B holds the shifting executory interest, which becomes possessory instantly upon the condition subsequent occurring, thereby divesting A's prior fee simple. We have now covered the shifting executory interest, which divests a prior transferee. We now turn to the second, and final, type of executory interest, the springing executory interest. Unlike the shifting interest, the springing interest does not cut short another grantee. Instead, it divests the grantor's retained interest, often a possibility of reverter or a resulting trust interest. Crucially, this type of conveyance creates a gap in possession. The property interest remains with the grantor, or their heirs, for a period, and then the springing interest jumps forward to the new grantee only when a specified condition precedent occurs. Consider the grant. 2a. If and when a graduates from law school. If the conveyance leaves the grantor holding the possibility of reverter after the prior estate ends, the springing interest springs out of the grantor. The visual representation emphasizes this gap, showing the interest literally springing forward from the grantor after a period of delay or condition fulfillment. We have now completed our detailed analysis of all future interests. To conclude this section, let us synthesize the key distinctions we have learned. First, reversions are unique because they are always vested interests retained by the original grantor. Second, remainders follow naturally without creating a gap. These are further categorized: indefeasibly vested, vested subject to open, vested subject to complete defeasance, or contingent based on conditions or ascertainability. Finally, executory interests operate differently. Shifting interests cut short a prior transferee's estate, while springing interests follow a gap, divesting the grantor. Understanding these precise classifications, who holds the interest, whether it is vested, and how it becomes possessory, is absolutely crucial. This foundation is necessary because these interests are precisely what the rule against perpetuities is designed to regulate, which we will cover in our next video.